The law that deals with crimes is called criminal law. Okay, very simple answer, very easy answer. The law that deals with crimes is called criminal law. That brings us to the next question. What is a crime? What is a crime? When an offense is committed, it is called a crime. Okay, so you can understand that offense and crime are two different things. Offense and crime are not synonymous. Okay, when an offense is committed, it is called a crime. So what is the meaning of offense? Offense is not crime. So what is an offense? An act prohibited and made punishable by law is called an offense. Okay, if doing something is prohibited by law and also made punishable, not only prohibited but also made punishable, then it is called an offense. That is the definition of offense. So when you commit an offense, it is called a crime. Okay, so the law deals with crimes. That is called criminal law. Is it clear to you? What is criminal law? What is crime? What is offense? Okay. Now, what are the major criminal laws in India? When we talk of crime, what are the major laws? We have three major criminal laws. Number one is the Indian Penal Code. Indian Penal Code 1860. Why 1860? Because it was enacted in that year. That is why 1860 is attached with Indian Penal Code. Okay, so 1860, it was still under British rule. India was under the rule of the British. So this Indian Penal Code was enacted by the British Parliament. There was no Indian Parliament at that time. So even much before India became independent. Okay. Number two, Criminal Procedure Code 1973. Okay. Why 1973? Till 1973, did we not have a Criminal Procedure Code? No, we had, but that was altered or amended. Okay. It was replaced by a new Criminal Procedure Code in 1973. Before that also we had a Criminal Procedure Code. Number three, Indian Evidence Act 1872. Indian Evidence Act. These are the three major criminal laws of India. Now, if you look at the three laws, number one is an example of substantive law. Indian Penal Code is an example of substantive law. What is the meaning of a substantive law? A substantive law gives us definitions. Okay, so we get definitions of offense and also we get the punishment for those offenses in a substantive law. That is the meaning of a substantive law. Okay, what is the meaning of adjective law? Adjective law is also called as a procedural law. So we get a lot of procedures from Criminal Procedure Code and Indian Evidence Act. Together, they are complementary to each other. You cannot enforce Indian Penal Code without Criminal Procedure Code and Indian Evidence Act. And without the Indian Penal Code, Criminal Procedure Code and Indian Evidence Act are useless. So they complement each other. To enforce IPC, you need CRPC and IE Act. Is it clear to you? So a substantive law is incomplete law. Only when an adjective law is added with that, it becomes a complete law. It's like a set. Okay, the set is incomplete. Only one. Only IPC is useless. It only gives you the definition and it tells you what is the punishment. But how to ensure that punishment, how to enforce that definition, that is not written in IPC. That is written in CRPC. What is a proof? What is an evidence? How to bring that proof? That is written in Indian Evidence Act. So all this together is called one set, substantive law and adjective law. So Indian Penal Code, CRPC and Indian Evidence Act are major criminal laws of India. Okay. Now let us go back in history little bit. Okay. Indian Penal Code was drafted by the first Law Commission. The first Law Commission was headed by Lord Thomas Babington Macaulay or Lord Macaulay. It was established in 1834. The first Law Commission of India was established in 1834 under the Charter Act of 1833. So this was a law passed by the British Parliament, Charter Act of 1833. And in 1834, the first Law Commission was established. This law commission drafted the Indian Penal Code. However, it became a law only in 1860. So this is an article written by Lord Macleay, okay, addressed to the British Parliament on 2nd February 1835. Okay, so when you get the PPT, you can go through it. It's very interesting, but I have introduced it because it is about Lord Macleay, okay, who is the chairman of the first law commission. So after the partition of the British Indian Empire, the Indian Penal Code was inherited by successor states. So the same Indian Penal Code was continued to be used by all the countries which were under the British rule, even after independence. Okay, Pakistan also is using the same Indian Penal Code. Bangladesh is also using, Myanmar, Sri Lanka, all these countries. Okay, more or less same. Okay, some minor modifications they have done, but basically all these countries use the same penal code which India is also using. The draft of the IPC was prepared by the first law commission chaired by Lord Macleay and submitted to the Governor General of India Council in 1835, based on a simplified codification of the law of England at that time, also derived from Napoleonic Code and Edward Livingston's Louisiana Civil Code. Louisiana Civil Code is from USA. The first final draft of IPC was submitted to the Governor General of India in 1837, but the draft was again revised. The drafting was completed in 1850 and the code was presented to the Legislative Council in 1856, but did not take its place on the Statute Book of British India until a generation later, okay, following in 1860. The draft underwent a very careful revision at the hands of Barnes Peacock, who later became the first Chief Justice of the Calcutta High Court and the future Pune Judge of the Calcutta High Court, who were in the Legislative Council, was passed into law on 6th October 1860. This date is very important. When was Indian Penal Code enacted? 6th October 1860. When it came into operation? On 1st January 1862. So the Indian Penal Code is in existence from 6th October 1860, but it became a law enforceable only from 1st January 1862. That is called the effective date. The code also came into force in Jammu and Kashmir from 31st October 2019. Before 2019, IPC was not applicable in Jammu and Kashmir because they had a different penal code. It was called Ranbir Penal Code. However, 31st October 2019, that Article 370 was replaced and Jammu and Kashmir Reorganization Act came into effect, and because of that IPC became applicable even in Jammu and Kashmir from 31st October 2019. Okay.